Hi, everybody. It's Jim Black from Know Before You Owe. We have a special guest in our studio today. Shelli Strahle is here from Legacy Planning Law Offices, and it's so great to have you in person. Shelli and I have been friends for a few years and been involved with a lot of committees together in our community here in Santa Cruz County, California. And Shelli is one of the top lawyers, attorneys, and estate probates in our county. She's won several awards, Best of Santa Cruz, the Sentinel, and a few other magazines. And you're always willing to share advice, share perspective, and help people make better decisions. And so I'm excited to have you here today. We're going to be talking a little bit about some of the important things for homeowners and also some of the important things for families when they have to make big decisions. Maybe there's a death in the family. Maybe there's a divorce. Maybe there's a new trust that's been established. All of these things play a role, and you play an integral role in all those different scenarios that can come up. So thank you for being here.
Yeah, thanks for having me.
Awesome. So let's talk about how you got first started in law. You went to McGeorge, I know that.
I did.
And tell me how you got into it. What motivated you to get your law degree?
So when I was 12 years old, I met an attorney, and he just talked about how law makes you see the world differently. And I was moved, and I announced to my parents when I was 12 years old that I was going to be a lawyer, and they kind of laughed about it. And you know what, 12-year-olds say lots of things, and I stuck to it. And so
that's awesome.
Years later, I went to law school and became a lawyer.
So cool. That's amazing. That's very rare. Normally people say firefighter or baker or something else. That's awesome.
Well, in first grade, I was going to be a bus driver.
Okay, right, cool. It's not too late for that. Maybe when you retire, you can have a bus. I used to have a bus. That's another whole story altogether. We'll talk about later. So part of this whole journey is making sure people understand that a will and a trust and the services around there are important to really understand before you make big decisions. A lot of people here in the Bay Area, California, may have owned their home for a very long time and may not know all the different potential outcomes by not getting good advice, right? People wait to the last minute, or they count on the wrong professional to help them make that decision. So can we start first with one of the most important topics that we know about, which is known as Prop 19, or Proposition 19 here in California, has to do with estate planning. So do you mind sharing some more information about Prop 19 and things that our audience should be aware of before they make a big decision?
Sure. So let's talk about the flowery, fun, exciting side of Prop 19, and then we'll talk about the negative side of Prop 19.
Okay, you got it. You got it.
So the good aspect of Prop 19 and why everybody voted for it was that you can move your property tax rate 3 times in the state of California. So if it's your principal residence and you want to move your property tax rate to another principal residence, you can do this under Prop 19 and potentially keep your property tax rate. But there are lots of little caveats along the way. The timing matters on if you buy the replacement residence first, or if you vice versa. And then there's a hard 2-year deadline. So they have no exceptions. So if you're going to be doing this, you want to be planning right away, moving forward right away, not delaying, because things happen in sales fall through. And if you're doing this at the last minute, the other thing is a lot of people, they think this is so exciting and they want to do this, but they don't think about the income tax consequences. So even though you're able to transfer your property tax rate, you could be hit with significant income tax consequences if you bought your house a long time ago and now it's escalated astronomically in value. And so that may be, so you really need to talk with a CPA before you do this. So you were mentioning talking with the right professional.
That's huge. So again, for the audience, if I've owned my house in the Bay Area, California, and I bought it for $100,000 and it's now worth $5 million, I get excited that I can move my property tax base. It's probably based on the $100,000 number. So that would be maybe $1,500 a year, versus if I bought a $5 million house today, not having this proposition from the state, I could be paying about $70,000 a year. It's substantial. So in this example, it's $1,500 versus $70,000 on a yearly basis. Flip side to that, like you brought up, we're not tax advisors. But the flip side is that's great. But if you sell your property and have a large gain, that's different than saving money on a payment for your property taxes.
Right. And then on the inheritance side, children receive a step up in tax basis at your death. So if you're trying to leave a large inheritance for your children, you may be inadvertently stealing a lot of their inheritance by moving to a new property because they aren't going to get that step up because you're going to pay the tax on that. And so they don't get that. So a step up in tax basis is they would get the value at your date of death as their tax basis instead of the price that you paid for the property.
Very important information. And unfortunately, a lot of people probably do this in the reverse order. They talk to their real estate professional first. They get emotionally attached to moving or a new property or some being closer to their grandkids or the ocean or mountains, but they do it in reverse order. So they should come talk to you and the CPA first, probably the mortgage guy third, to make sure that they can afford or have options to be able to buy a property. And the last one probably is the realtor in this example.
Yeah. And then once you sell the principal residence or you buy the replacement residence, the 2-year clock is already ticking. So I highly recommend discussing all of this with professionals before any transaction happens.
And that would be similar to what we see in 1031 exchanges. That's when you're replacing an investment property with a like kind investment property, and you have certain windows of time that you have to complete this. So
correct.
Make sure you can perform, because if you can't, it's maybe not worth even doing.
Right. Or it's too late to do.
Or it's too late to do. That's awesome. That's really good insight right there alone. So let's talk about the areas and the counties that you work in. So as a attorney, can you work in all counties in California?
Yes, I'm licensed in California. I prefer on the probate side to only take probate cases around here, just because probate cases, there's a lot of local rules that may come into play. But for setting up a living trusts are valid nationally. I'm only licensed in California, so I would only create a trust for someone that lives here or someone that has a lot of California assets where they choose to set up a trust here. But yeah, it's mostly California.
Good to know. And then in terms of trusts, that's another thing we run into a lot in real estate is sometimes if someone is incapacitated or is no longer of sound mind, they are not legally allowed to make decisions, and there may be a loophole where no one in the family can make that decision if they haven't properly planned for it. Can you share what they should be doing to prepare for that? And that's contacting and hiring you, right?
Yeah, so you need to have a power of attorney. So for my clients, I always do a general durable power of attorney, which is valid nationally, and then a California power of attorney, which is valid here. The reason I do both is the national one is wonderful. It's bigger, has every potential power you could possibly ask for, but a financial institution has the right to deny it for no reason. They can just say, we sent it to legal, we don't feel like accepting it. And so I always do the California one as well. The California one, the short form statutory California one, if you just do that and you only have that, you can also run into issues. You can run into issues with not having the particular power because they like to see borrowing powers and other powers in detail that aren't going to be necessarily listed on the short form. So I always include a short form with extra pages attached. So you have the best of both worlds. And then if you take that to a financial institution and they say that they aren't going to accept it, then I always tell my clients either to direct them to me or let them know the law they're violating. And they actually are responsible for the attorney fees if you have to enforce the power of attorney. And the reason we want to set up power of attorney documents is if they don't get accepted, then you end up having to get a conservatorship, which is very expensive. You have to be bonded. There's a court investigator. It's a whole process.
I imagine that's not a quick decision either. So if someone has, maybe their health goes downhill quickly and they have to move, they may be delayed in that process if they don't have these things properly put together.
Correct. And there are emergency conservatorships, but again, this is something that is very costly. You may end up spending more money on the conservatorship than you would for the entire trust package.
Got it.
And if you're just getting a power of attorney, that's even cheaper.
And does that kind of also play a role with another topic you do, which is healthcare directives? Like, is that in a similar document? Are people planning ahead to make sure that everyone knows what that person is electing to have in case they cannot make a decision for themselves.
Correct. So that's who makes healthcare decisions for you. And it's also come up that gives post-death authority. So if there's a dispute about someone wanting to take ashes somewhere else, so the healthcare directive actually gives, if you want it to, it gives post-death authority to your agent. The next in line would be immediate relatives. The next in line is who is dealing with the funeral home. So there is a hierarchy for who gets to make that decision.
So if I want to become a firework, I should put that in the document. Okay, good to know. Cool. So what else all about Shelli's approach is she's very hands-on. She's an amazing office here in Capitola, California. I've heard nothing but great things from all the people we've worked with directly or indirectly that you've helped. And, it's important to have the right professionals in your corner for any big decisions. You don't go with the cheapest option. You don't go with the fastest option. You go with the person that is listening, has your best interests in mind, and is going to be there and remember and take the time and energy to really take care of it in the right appropriate way.
And be thorough. So what I have seen, a lot of people, they want to just go to a paralegal to save money I don't need an attorney. My estate, the thing I always hear is my estate is simple. It's never simple.
Yeah.
And what I've also learned is never trust the client on what they think is true. So I always verify that it's true. So someone comes to me and they say, I hold property this way, or we took title this way. I'm going to pull title, investigate how you hold it, see if it really is community property, because that's the other thing is joint tenancy doesn't get the double step up in tax basis, which means that on the second death in a couple that you get the value of the second spouse to die. So if someone goes from joint tenancy directly into a trust, they're going to get a frozen tax basis on half the house. So we always want to check. But then the other thing is you don't want to automatically assume it's community property. So if you go to someone that doesn't understand the legal consequences, or just, my real estate agent told me to do this, so a lot of people, they just think of, okay, I want the double step up, but they don't realize what that means in terms of divorce. So in terms of divorce, let's say one spouse put all the money toward the house and it was their inheritance, or they had this money before marriage, or they own this house before marriage, and they change it to community property. If you divorce, that other spouse now gets half. So it's not necessarily an automatic, we need to do this for tax purposes. It's really evaluate the facts and circumstances of every case to make sure that it fits and it's the best thing to do.
So creating a custom approach, really listening to the needs, and then also, unfortunately, looking at the worst case scenarios that can come out of a situation, right? You have to see both good and bad to make sure that you've protected the interests of the parties that you're representing, right?
Correct.
That's cool. So a lot of people are investing on title. So I'm a lender, right? We work with realtors and we work with title companies. Here in California, the title and escrow, at least in Northern California, is normally the same party. How many different ways can you invest in real estate? I was told it was like 6 to 8. I don't know if that sounds right or not. I know there's common ones, but are there a few common ones? The joint tenancy, tenants in common?
Well, yeah. So there's joint tenancy, and that is a good way to vest title if you want to hold property with a spouse, but one spouse put forth the money. And so you don't want to make it community property. So that way you can trace back that it was your own separate funds. So joint tenancy is good for that. If you're taking title with a child and you want it to go to that child, or even with a non-child where you guys are both putting the money in and you want it to go to the survivor. So then you would want to take as joint tenancy because it automatically goes to the survivor. A lot of people think, well, let me just put I'll just put my child on title because then I don't have to get a trust. Several problems with that. So before Prop 19, the problem was if that child gets in a car accident and ends up owing a lot of money, they can take your house now. So that's an issue. The other issue is now that we have Prop 19, if your child doesn't make that house their principal residence, you're going to get reassessed on 50% of the value of your house to fair market value if you add a child on title. So after the passage of Prop 19, is a disaster to add a child onto title. So if you have a trust, then that doesn't happen. So
very interesting. And that actually brings me up to a scenario that just happened to one of my clients. Unfortunately, they weren't working with you. So that was mistake number one. They had a property in the Silicon Valley area that they had bought for $200,000. Their property tax yearly was about $3,000 that they paid. They were going to downsize. He had some needs that he needed to be in a elderly facility. And unfortunately, he thought he should sell his property without first consulting the CPA and the estate planner. Well, at the 11th hour, he realized that if he sold the property, half of the inheritance for his kids would be gone in taxation issues around income. So now he's found a way to have his two daughters that live outside of the state of California turn into rental property, which I don't know if that even protects him. But now they have some more time on their sides versus an event of selling the property. So again, this gentleman thought he was protected, probably went with the wrong professional first that didn't know the laws, and then unfortunately got to the final decision to not have to sell the property. So the realtor worked really hard to get the property ready to go and put effort in and time. And unfortunately, if he would have gone to you first, that realtor would have saved their time and energy to realize, okay, the best interest is not to sell this home.
Well, and then they have to make sure that it stays principal residence. So if they're renting it to third parties and, filing taxes that they're getting income from this and all of that, it's not principal residence of the deceased when he dies. So we didn't talk about the not so great part of Prop 19. So under Prop 19, let's first talk about Prop 58. So Prop 58 allowed that you could give unlimited amounts of principal residence, no matter what it was worth. You could transfer it to your children. They didn't have to live there as long as it was your principal residence. And then you got $1 million of assessed value in other properties. And $1 million in assessed value, not fair market value. So if you purchased a lot of properties a long time ago, you have multiple properties that could fit within that $1 million. And those could also transfer to your children. Now, under Prop 19, it must be the principal residence of the deceased or the person making the gift, and it must become the principal residence of the child or grandchild if parent is deceased who is taking it, and they must make it their principal residence within 1 year. And it's a hard 1-year deadline, and you have to file the paperwork. Under Prop 58, you could file it 10 years later, and then they would just make it retroactive. Now, if you are dealing with grief and just have a lot on your plate and you let that 1 year pass, you're going to be reassessed at full fair market value, even though you fit the category of someone that could do it. And then, so you have to do that paperwork and get that in within 1 year. And so a lot of people have to be careful of what they do when their parents are aging, of how they're going to change. They want to make money to pay for care, but at the same time, they might be shooting themselves in the foot on being able to take it as principal residence later. And then another thing is that if you don't have a trust and your property gets stuck in a probate, because when you don't have a trust, the property ends up in probate, it takes a long time. It's 2 to 3 months to get to file and have the court hearing to make someone executor. Then there's a time period for creditors. You have to get an appraisal. So all of this time that it's stuck in probate, you're going to be reassessed at fair market value. And then if you have a trust and everyone's getting along, you can just sell it as quickly as you can if you know you're not going to make it principal residence.
So all I'm hearing is work with trusted local professionals on large financial decisions to make sure you're protected. Don't work with some chop shop or online resource that doesn't have your best interest in mind.
LegalZoom's not going to tell you.
Yeah, LegalZoom is not, yeah. And also make sure that you know that every scenario is unique and customized, right? You don't have one document you give everybody, right? That's probably why it takes time and effort to do this.
You need to be intentional about everything that you do in regard to this. You need to be intentional about seeking the advice of the CPA before making the decision, seeking out the advice of an attorney, an estate planning attorney, maybe even a real estate attorney to figure out what you should be doing. financial planner to make sure that this makes sense in your overall financial plan, and then talking to the realtor and anyone else. So you need to be really intentional about a lot of these things. Once you make the decision, you can't go in reverse.
And a lot of these things are chain reaction events too, right?
Correct.
You do one thing here, it leads to other outcomes down the road that you may not have wanted.
Correct. And then going back to your, what are the different types of vesting? So we were talking about joint tenancy, and then there's tenants in common.
And this is California, by the way.
Correct. Every state is different.
Yeah, every state is unique and different. So we're talking California.
Correct. And even when I create a California trust, if my clients have out-of-state property, then we seek an attorney in that state to draft the real property deed, because it's state specific and every state is different. So we can still get it into our California trust, but it's going to be according to that state law for the deed. And then another thing about that is that if you do not have a trust and you have out-of-state property, you're looking at a probate in every state where you own property, not just California. Whereas if you have a trust, there's one trust administration.
Wow, that's huge too.
Yeah.
Wow.
So back to tenants in common. So tenants in common is how you would hold property, maybe if you inherited property with siblings, or you came in with other parties and you're putting your money together, but you don't necessarily want them to inherit the property if something happened to you. So tenants in common is where you have an interest in the property, but your particular interest is going to go according to your estate. So if you have nothing set up, then it's going to go according to intestate succession, which means it just goes according to California state law and it ends up in probate. If you have a will, it's going to go according to what you want in your will, but still ends up in probate. And then if you have a trust, you want to get your tenants in common interest into your trust, and then it will go according to your trust, even though other people are on the property on title.
Got it. So I could have my name, Jim and Jane Black, on the title, but if I have a trust that's set up and encumbers that property in the trust, it's okay that my names are just on that. It should be the same names, but it's covered, is what I'm hearing.
Correct. Well, and you putting your interest in trust doesn't affect the other people who are on title that also own it as tenants in common, because you sort of have separated interests in that scenario.
Gotcha.
Whereas joint tenancy, it's as a whole and you just inherit from each other. Tenants in common is you have your own interest that goes according to your own estate. And then we have community property. So community property with right of survivorship is the best way to hold title if you are married and you bought the property during marriage, you don't have a prenup, so it's just something that you both use community funds to buy the property, then it should always be community property to ensure that you get the double step up in tax basis for your children. And so it's just a really great way to hold title. So you should never be taking title as joint tenants if one of you didn't put forth all the funds. If you're just coming in as a married couple, you work together, you earn this together, always community property.
Great insights. Thank you so much. To all of our guests that are listening or watching, that's so important to talk to professionals. Again, we'll put all of Shelli's contact information on the podcast, on the YouTube channel, and on all of our social media for sure. So one thing I always like to make sure we cover in our show, it's called Know Before You Owe. Our goal in this show is to help people make better decisions in their own life, learning from other professionals that may have expertise in some category or life perspective. So I'm going to ask you the question, if you could look back 20 years ago in time, so you'd be like 3 years old, what advice could you give yourself back then that you could help you today with being more successful or happier or whatever it might be that we can all learn from?
I think I kind of already mentioned it before. I think just being more intentional in all of my planning and my decisions and my life, everything. And I wish that I had purchased a house when I was 3 years old.
Nice. Very cool. That's awesome. And a little fun fact, I met Shelli at a restaurant one day, and her son was just the cutest little kid at the time. Now he's like 10 feet tall. But his goal was to be a YouTube star, right? So now you get to be a YouTube star for Liam, right?
He's gonna be very jealous.
Yeah, we'll make sure we get a shout out for Liam on this too. But I always appreciate hanging out with you, Shelli. You're always exciting, and I love that you work hard and you play hard. You enjoy life. You make it count. You're also an exceptional dancer, right? You love dancing, right? What's your favorite type of dancing nowadays?
So when I have time, which is not a lot these days, I like to do salsa and bachata dancing. It's great aerobic exercise. It's fun, and there's a community, so
cool.
I enjoy that.
So you can go like from city to city, and there's like an embassy for dancing. Is that kind of the
yeah? And I feel like no matter where I go, I probably know one person.
That's so cool.
So it's something where you can just go somewhere, and even if you don't know someone, everyone is very welcoming, and it's a safe environment.
That's great, because that's exciting that you live life, you enjoy life, you help a lot of people, and you help them today, but they don't realize how much you're helping them decades ahead, legacies ahead, right?
Well, and actually one other point that I wanted to bring up that I don't think we covered. So a lot of people think, married couple, no kids, I don't need to worry about estate planning because I don't care who gets my property later. Well, what they don't consider is that assets don't automatically transfer to surviving spouse. So your spouse has a business, your spouse has an account that you aren't on and you're not the beneficiary. All of that those assets are gonna be frozen, potentially probated. So if you can prove it's community property, there can be someone can file a community property petition and get the asset deemed to be community property and deemed to be yours. If it was definitely, like maybe there was a prenup, or maybe this spouse had this account as an inheritance, that account or that business interest is gonna be probated as between the spouses. So even couples that, they don't care who's getting their money when they're both gone, they need to do estate planning as well to make sure they're covered as between each other. And then a lot of people don't understand, if they aren't citizens, we have an unlimited marital deduction for citizens to be able to inherit from each other. If you have a large estate and you are not a citizen, even if it's just one of you who isn't a citizen, there could be massive tax consequences to inherit just from each other. So, if you set up a trust, there are potential strategies to minimize that.
Crazy. Well, I learned a lot today. I'm going to definitely be more deliberate in my goals, personally and financially. And this backdrop, by the way, in our video is actually a backdrop of Shelli's office logo. So this is Natural Bridges in Santa Cruz County. It's
the color and the ocean.
The ocean. Sorry, I thought this was too. But this is a place that ironically is less than 3 miles from where we actually are filming right now. So this is actually a pretty special place to live here on the Central Coast in California. I'm really happy to have you on the show. Thank you for stopping by. And that wraps up our show. Please follow us, like, subscribe to us, and know before you owe. I'm Jim Black. Shelli, thank you so much for your time. And I need to get my trust reevaluated here pretty quickly. So thank you again.
Thanks for having me.
Take care.